At 4:08 on Tuesday, July 15th. Mr. Young, would you call the roll, please?
Yes. Member Fisher? Member Fisher did inform us at the last meeting that she would not be able to attend today's meeting. Member Hepner?
Present.
Hepner present. Chair Washburn?
Present.
Washburn present. We have a quorum. I do not know of any agenda changes.
All right. Just to let everybody know, I'm chairing this today because I have been chairing this committee for the past several years. I don't intend it to be a permanent position for me now, but for today, I'm who you have. All right. Mr. Young, could you call item number 2, please?
Item number 2, adoption of the May 20th, 2014 and June 17th, 2014 Compliance and Amendments Committee meeting minutes.
So, Member Hepner, do you have a motion for us?
I move to approve those meeting minutes. I have reviewed them.
Okay. I second the motion, and I have some very minor corrections that I'm going to physically give Mr. Young. All right. Is there any public comment on the motion to approve the minutes from the last 2 meetings of the Compliance and Amendments Committee? Okay, seeing none, Mr. Young, would you call the roll, please?
On the caller roll, Member Hepner?
Aye.
Hepner, aye. Chair Washburn?
Aye.
Washburn, aye. The motion passes.
Mr. Young, would you call item number 3, please?
Item number 3, file number 14010, hearing on the status of the order of termination. Michael Petrellis against Matthew Godet, Mayor's Office, and Mayor Edwin Lee for violating Sunshine Ordinance Section 67.21C and E. All
right. Right before the meeting, Mr. Young distributed a memorandum or letter from the Mayor's Office regarding this matter. It's dated yesterday. This is the first I've seen it. It's a lengthy letter. I haven't had a chance to read it. So, is there anyone here from the Mayor's Office? Oh, okay. So, that's helpful that you're here. But I just want to say that I haven't had a chance to read it. So, what we're going to do now is we would like to have an update on the order of determination and efforts to comply with it. And we'll first hear from the complainant, who will bring us up to date. And he'll have 5 minutes. The respondent will then have 5 minutes. Then typically what happens is members of the committee have questions for both parties. So it's a regular hearing. But just up front, I haven't had a chance to look at this at all. So we can move forward if the complainant wants to move forward under. Okay, all right. Yeah. So, Mr. Petrellis.
Good afternoon. My name is Michael Petrellis, and first of all, regarding this letter, it contains many of the same language and arguments that were presented to the full task force back in June. That's my read of this document, which Victor Young emailed out today. And looking at it now on paper, I really can't see if there is anything substantially new from what was presented from the mayor's office at the June 4th full task force. Since the June meeting, I have not received any more documents from the mayor's office. And I wish to state again that I cannot believe that the mayor's office does not have these records that I was looking for, such as a list of all donors to the protocol office, amount each donor gave. I believe that there is a calendar for both Mr. Matthew Godot and for Charlotte Schultz, regardless of Charlotte Schultz being a quote-unquote volunteer for the city. I believe that calendars are kept by the mayor's office, and I do believe that there are many records related to this party. That was my concern in December. A party here at City Hall paid for basically with city dollars through a $250,000 grant to the San Francisco Host Committee, and that when you have the mayor, a number of local dignitaries, and foreign diplomats gathering in City Hall, there are many documents as to who is paying for it, security, how you're going to keep out the public, etc. So I think that sums up where we're at. Thank you.
Thank you. And now, Mr. Goodell, you have 5 minutes to respond to Mr. Petralis and to our order of determination.
Thank you. I'm Matthew Godot with the Mayor's Office of Protocol, and I'd like to thank the members of the Compliance and Amendments Committee for the opportunity to speak with you today regarding the June 12th Order of Determination for file number 14010. The June 12th Order of Determination was received by the Mayor's Office on July 10th, 2014, and our custodian of records submitted a written response on July 14th, 2014, which I think you're in receipt of now. I understand that the task force did not find that the mayor's office withheld any responsive documents. However, the order does ask that we provide additional background information, and this requested information was included in our July 14th letter. In summary of that letter, since I gather you hadn't just received it, the order asks that we provide documents regarding the SF Host Committee's December Diplomats Party. We've previously provided Mr. Petralis and the task force with all available records that were requested, namely the requested guest list. We do not have any of the other requested records, such as the budget or the list of donors. The order asks for contact information to any party who may have documents related to Mr. Petralis' request. And since it's December and January requests to the mayor's office, we understand that he has received records from other city agencies who provided him with documents related to his various requests. Mr. Petralis has already received details from the city administrator's office regarding city grant funding from Grants for the Arts to the host committee and the special events committee. He has also received records from the controller's office related to city funds issued to those two committees. Mr. Petralis has also received an overview of my job classifications and responsibilities, a position that's funded by the airport. The order asks that we provide budget information and relevant index codes in relation to funding for the Office of Protocol. As we informed Mr. Petralis and the task force, the mayor's office has a budget of operation for the entire mayor's office as a whole and does not include separate line items for the Office of Protocol, which is what we understood Mr. Petralis was asking for. The order asks that we provide information regarding the relationship between the Office of Protocol and the SF Host Committee. As we explained in our February 4th, 2014 response to Mr. Petralis' task force complaint, since adoption of the 1998 Proposition F, two private nonprofit organizations, the San Francisco Host Committee and the San Francisco Special Events Committee, fund the Office of Protocol's work, including the annual Consular Corps holiday event in December. This support is noted on the Mayor's Office Gift and Disclosure webpage. Donations and grants to the two committees and their budgets are not public records in possession of the city, although we understand Mr. Petralis has secured recent tax filings for past years for the Host and Special Events Committee, all of which are available online to any member of the public. These tax filings disclose major programs and expenses of the two committees, including the planning and support of San Francisco city functions involving the Consular Corps, such as the hosting and participation in the holiday season event. We in the Mayor's Office do not have any public records about the Host Committee or Special Events Committee's budgets for specific programs, including the Consular Corps annual holiday reception. I am now confident that Mr. Petralis has received all available public records related to his request and to this complaint, and I believe that Mr. Petralis has now been directed to where he might find additional information or documents that are not available from the mayor's office. I do regret tremendously that I did not provide sooner to Mr. Petralis detailed information on where he or any other member of the public might be able to access the information he was seeking. We in the mayor's office, especially myself, are now better educated on how to respond to the public records requests specifically related to the office I work in, the Office of Protocol. I believe that Mr. Petralis has now received the documents and information he's seeking, or at least those that are available. And although the mayor's office does not have any additional records responsive to Mr. Petralis' request, we hope the committee today finds the additional information and the direction we provided to him are satisfactorily responsive to the order of determination as presented to us. Thank you.
Thank you. So, Member Hepner, do you have any questions for either party here?
Well, that was a bit hard to process because I haven't reviewed this letter and you were talking quite quickly. But I am trying to review this this latest communication from you simultaneously to get an understanding of what further documents, if any, were produced, what assistance was provided to the complainant in order to find additional documents. And I will say I have I do have a couple questions that maybe you've already answered, and if I ask them again, it's only because of my incredulity. Yes, I do share the complainant's concern that there is nowhere a budget or list of donors for the host committee's December diplomats party. But that's your representation at this point, correct?
Well, the donation to the Office of Protocol for the annual event in honor of the Consular Corps is from the San Francisco Host Committee, and that donation is reflected on the mayor's website.
So then the San Francisco Host Committee, which is a 501c3 nonprofit, they made the donation to the city to fund the party. Is that correct?
Correct, and that's noted on the mayor's website.
And whoever provided money to the host committee, for the host committee to then provide that donation to the city, that information you contend is not a public record or not in the possession of the mayor's office?
Correct.
Okay. Are those donations reflected on, to your knowledge, on the tax documents that the complainant has subsequently obtained?
I'm not aware. I don't know. Usually on a 990 form, you would, I think donations of a certain level or something like that, but I'm not certain.
I'll ask him. Okay. I'll ask him that.
Okay. Thanks.
Because I understand you may not know, but you have no understanding of where else that information may exist. Then
it would exist with the host committee, the San Francisco Host Committee.
Okay, and not with the mayor's office.
Correct.
Now, you are an employee of the host committee?
I'm an employee of the airport.
You're an employee of the airport, yes, who is funded by the host committee and the special events committee? No, I'm a direct employee of the airport. I carry out responsibilities. I believe that my job description was provided in the response to the order. Okay. Yeah. So it kind of outlines my work of what I'm required to do on behalf of the airport. But do you have any control over documents that are possessed by the San Francisco Host Committee or the San Francisco Special Events Committee?
They have their own financial office and their own board of directors that maintain their own records.
Okay, and does the mayor's office have any control over the documents possessed by either of those entities?
No.
Okay. I think that's the extent of my questions for you for now. Thank you very much.
Thank you.
And if I could ask the complainant. So the subsequent records that you've obtained, the tax documents from the host committee and the special events committee, is that accurate? Have you obtained those records?
Yes, I have.
And independently from the Sunshine request, correct?
Right.
Okay, and did those documents contain information that was satisfying your interest in obtaining these documents from the mayor's office, or?
No, it did not. And, we are talking in terms of the Office of Protocol, which is headed by Charlotte Schultz. She's wearing a hat as the director of the Office of Protocol. Mm-hmm. Then she puts on another hat as the executive director or president of the board of the host committee.
Right.
This led to some suspicion on my part. And then what we see, or what I see, is that the General Services Administration gives $250,000 a year to the San Francisco Host Committee, which just happens to be headed by a woman named Charlotte Schultz, who is also the mayor's director of protocol. Matthew is in the Office of Protocol, and then his job is actually related to the airport. Okay, I see something of a shell game going on here, and I am trying to follow city money that does go to the host committee. We all agree on that, okay? It's a $250,000 grant. And then how that grant is used by the nonprofit, and the General Services Administration doesn't get receipts from them. Mm-hmm. Well, somewhere along the line, I believe the mayor's office does have a budget. They have to provide food, security, drinks, decorations, etc.
Unless the meeting, sorry, I don't mean to cut you off, but unless the meeting is organized by and funded by the host committee, but. Is that not your understanding of I mean, for instance, there are numerous private entities that I understand that can rent out City Hall for a party, and I'm not certain who. It's my assumption in most cases that the private entity then funds the party once they rent out City Hall, but I don't know if City Hall then maintains a record of the budget of the allocation of funds submitted by the private entity to use City Hall, and I guess that's the question. Then that's where following the money becomes difficult for you, is you don't know how the money that's submitted by an admittedly private entity is used and allocated for different purposes. For
argument's sake, we'll accept that the party is hosted and only paid for by the host committee. But when you have the mayor invited and the mayor attending and the director of Office of Protocol putting on this event, wearing both hats, I believe that there are emails going back and forth, especially because you've invited hundreds of people. Now, one document I did get was a list of invitees, okay? I posted that on my blog. I do not believe that anyone organizes a diplomatic ball annually in City Hall where the mayor attends, all these foreign diplomats and local dignitaries, elected officials are invited, and there are no emails? I find that hard to believe. Those were part of the documents. I believe my original requests were for all responsive documents, communications, etc., that pertained to this party. Is that your recollection, Matthew?
Which is related to the budget.
I just asked Matthew if that was his recollection about the emails, and he's a little bit fuzzy, as am I, because let's face it, it's been 7 months.
Okay.
But I hope I've answered your question. If not,
right.
Let me know.
You have answered my question, and I share your sort of your independent skepticism about the intermingling of these entities, and will be forthcoming with my I don't know, and that's I don't know what you don't know and what you want to know. I have the representations here of the mayor's office, and I suppose I can ask him a couple additional questions, or if Chairperson Washburn has any questions.
Oh, I just have a couple questions for Mr. Petralis, and again, there's a lot of unanswered questions and a lot of mystery about how things really work. But I'm looking at actually the memorandum from our district city attorney dated May 29th. This was in preparation for the matter when it was heard before the full task force. And quoting from your December 27th request. It was an IDR for the full guest list, also the breakdown of all the city costs, electronic copy of the full budget for the Office of Protocol over a 2-year period, itemized breakdown of all the costs and fees. You don't say anything about email correspondence, though. I don't think you asked for all of that at that time. Was there a subsequent request for all available documentation regarding this event or regarding the relationship amongst these entities?
First of all, I stand corrected based on what you're reading back to me. I was wrong about my request included wanting to see the emails.
Mm-hmm.
I, off the top of my head, cannot recall a follow-up request for the emails.
Okay. So the other question I had for you is regarding the July 14th letter that we just received this afternoon. On the third page, most of the first 3 pages is background information, but letter C is addressing point by point our request in the order of determination. And Mr. Godot went through that in his remarks, but I'm just wondering, it looks like what's new here is the third bullet point where they're providing contact information for you. It doesn't look like there's anything new other than that. Am I correct?
I got lost there. Are we on page? We're on page 3, letter C, first bullet point.
The third bullet point.
Bullet point.
I'm just trying to see if there's any new information that's been provided for you in this letter.
No.
Well, okay. It sounds like you've gotten information from other sources other than from Mr. Godot. So, but that's not. I mean, that's important to you and for what you're trying to do, but it's not important in terms of what we're looking at here today, which is
correct.
The mayor's office compliance with this order of determination. And so one thing we wanted, the violation that we found was their failure to help you, point you in the right direction, help you find records that they didn't have but somebody else might. That was the violation that we found. So I'm just wondering if they've now done that for you in this letter C, the third bulleted, or any of the bulleted points. Have they given you additional information that we asked them to give to you?
No, and this brings me back to the question about emails. For argument's sake, I'll put out there that there were emails about the guest list and related matters to the party. I would say that the emails would qualify as responsive documents that should have been provided to me, again, for argument's sake, assuming that there were emails going back and forth in organizing the party.
Right. Now, I agree that they would be helpful. And for argument's sake, I hear you. I'm just trying to look at the order of determination, what we asked them to do, and whether or not there was compliance. So that's kind of where we are today. It's a rather more narrow discussion, although this is all a big mystery to us. We're trying to figure out the money trail and their interrelationships between these entities. It's fascinating. Okay, so to answer my very specific question, in this letter dated yesterday, is there new information provided to you that will help you in your quest to understand all of this better? And I was reading through, again, I haven't had time to really digest it, but I was wondering about that third bulleted point. third bullet point, because we asked the mayor's office to provide contact information to any party who may have documents related to your request.
They have not, and I assure you that within a few days I will be filing a new request for the emails.
Sure. But I'm wondering, so right here, they say they're not legally required to do so, but actually you are legally required to do so to give information like this, providing contact information for the host committee and special events committee. So that's here.
Right.
Okay, so that's new information to you. I mean, you may have gotten
that
it
has been presented before.
By them?
Yes. If I'm not mistaken, they have told me to get in touch with Pamela Miller from the host committee.
Okay.
She's the financial officer for them.
All right. Okay, thank you.
Through the chair.
Sure.
Mr. Petrellis, if I could just ask you a couple more questions.
Certainly.
Just I'm just going through this point by point. So, for instance, on the last page, the top bullet point, regarding the order that the mayor's office provide budget information and relevant index codes in relation to funding for the Office of Protocol. When it says this piece of information here, as to the director of the Office of Protocol, Matthew Godot, his salary is not part of the budget for the mayor's office. His salary is funded through the San Francisco International Airport. Did you previously know that?
Yes, I did.
Okay.
However, in reading the first line there, quote, provide budget information and relevant index codes. Not sure what an index code is. I've not received any index codes in relation to funding for the Office of Protocol.
Well, my understanding of an index code with my limited experience with the city budget is that index codes attach, job codes attach for payment of different employees, for payment of different items that a code will attach. That's what I'm assuming.
Information I did receive. If that's what we're talking about, yes, I did receive that about Matthew.
Okay. And also, I think the order is asking the mayor's office to provide this information to the extent that it exists. And I share your frustration if it does not, but it may not. So, otherwise, do you dispute that Mr. Godot's salary is funded through the San Francisco International Airport?
No, I don't. But I believe that there are documents that he produced related to this party back then in his responsibilities that emails back and forth to the host committee.
Okay. Because the way I'm thinking right now is that they have provided some information. I wasn't there for the original complaint, so my apologies if my view of this is a bit narrower than you would like, but it appears to me that they've provided some information which you already knew, some information which you may have acquired from independent sources, and if that's the case, then what we're left with is the frustration that there's the intermingling of private and public funds, and that's a conversation that I think is very important, but maybe not within our purview on the Sunshine Task Force.
Right, and in this last bullet point on page 4, you asked that they provide information regarding the relationship between the Office of Protocol and the SF Host Committee. I've not received any information. I don't believe the task force has either, and if you have, you would have shared it with me. And this gets back to my original suspicion that there is a relationship between this office and the Host Committee putting on the party. Let me clarify that further, that there are more public records than the invitation list that put on, okay?
If I may just ask Mr. Godot just a couple brief questions, because I do find that last inquiry interesting. Information regarding the relationship between the Office of Protocol and the SF Host Committee. Then you proceed to provide, a short paragraph of information that provides a summary of the relationship.
Right.
Is that the extent of the information that was provided in response to that order? This paragraph that starts as mentioned in our
As
earlier...
far as I'm aware, yes, but additional information was provided to him through the 990 forms from the San Francisco Host Committee and the San Francisco Special Events Committee that he secured. In those 990s, it goes into great detail about talking about the work of the Host Committee, the work that the Host Committee does on behalf of the city, and that's information that's readily available to the public.
And does that great deal delve into specifically the relationship between the Office of Protocol and the SF Host Committee?
I think it's just in general of the work the Host Committee does to support the city in general, but the Host Committee only really works with the Office of Protocol. And those donations to the mayor's office are, again, noted on the mayor's webpage, so it's readily available to the public to know that relationship exists.
Okay. So now, I'll say that this order, that again, the language of that order, information regarding the relationship between the Office of Protocol and the SF Host Committee, if we're looking just at that language, it could be interpreted to be extraordinarily broad. And I'm wondering how you interpreted the meaning of that order, that specific element. What qualifies as information?
I mean, as you said, that can be defined in many different ways. I interpreted it as information related to what the Host Committee does in support of the Office of Protocol. The Host Committee receives donations and in turn supports events of benefit to the city through the Office of Protocol. And that's a relationship that has existed for, since the 1980s.
And has that been a static relationship since 1989?
Pre-1989, yeah, it's been a very active relationship. I mean, if you want, I can go into the history that I know of the two organizations. But San Francisco Host Committee was set up when Queen Elizabeth visited San Francisco, and then Mayor Feinstein didn't want to use city funds to support the visit, so they established a nonprofit to raise donations to support that. The San Francisco Special Events Committee was established on the 50th anniversary of the Golden Gate Bridge to support that event with private funds. I mean,
I appreciate it occurs to me that might be information that should have been provided to Mr. Petrellis. Whether it was what he was looking for or not is a separate inquiry. But that's information, I'm concerned with what Mr. Petrellis is actually looking for. I don't think, with all due respect, Mr. Petrellis was looking for, the 5th anniversary of the Host Committee and Queen Elizabeth's relationship to it. So,
Right. Well, and again, it goes back to what information he's seeking and what information is available through public documents.
Do you have an understanding of what he's seeking, and do you think that the mayor's office has performed, a good faith effort to provide that information?
I think we've provided a good faith effort of providing the public records that are available. Those records that we didn't have available, he was directed on to the controller's office to find what records they might have available, to the city administrator's office, to the airport, to the city attorney's office, to provide whatever information might be available. He's been in touch with the Host Committee and the Special Events Committee. He's secured the 990 tax records, which are readily available to any member of the public. I don't know how else we could have been more helpful. I've learned definitely through this process of how I might be able to be more helpful in a more timely manner and to help the public receive information on the Office of Protocol, because I think we do really great work, and I'd be happy to provide that information to anyone.
Sure. And excuse me just for being so thorough. This is actually, for the public's notice as well, this is my first time sitting on this subcommittee, so I may be being a bit thorough, but
Great.
thank you.
She's looking for a new chairperson, I think.
Well, my next question then is, did you include in the definition of information regarding the relationship between these two entities? Did you include in that definition of information emails?
No, I mean, I can say that there are no emails available related to the specific request that he had about the budget and how especially the annual Consular Corps holiday party was funded.
Okay, and how do you know that?
Because I know I just don't have those. I mean, he's welcome, of course, to submit the request, but it's just a matter of those. The budget items related to specifically the Host Committee's expenses are with the Host Committee, and they take care of those matters. When he was directed on to other departments that might have information on the costs associated to those departments, for example, the events department, the sheriff's department, those records, those public records, aren't contained in the mayor's office. We don't have those records.
And the mayor's office never sent or received emails regarding the budget of this host committee party?
Not that I can recall, but it's a matter of even having those emails still. I mean, and the records retention policy that the mayor's office has.
I've understood it's pretty tight.
I'm not the custodian of records, but it's a matter of what's available when the request is received, and we provided him what was available at the time that his request was received, and the subsequent order of determination and documents that were available at that time as well. So there have been no documents that have been withheld, and when we didn't have those documents or information, we referred them on to other departments or agencies or the nonprofits financial offices. He's been in touch with the nonprofits attorney, I believe. So it's, we've referred him on to where he can get that information if it's, available.
Thank you.
Thank you.
Oh, just a second. Mr. Godot, you now have 3 minutes to offer a rebuttal.
Okay. To Mr. Petrellis's remarks, or to just in general?
In general, okay. Any closing remarks?
I think just in closing, I'd like to say that I believe that we provided with Mr. Petrellis with all the documents that are available, and when those documents were not available, I believe that we did a pretty good job, maybe not necessarily in as much of a timely manner as I now wish that we had, and I definitely know for the future to provide that information sooner than I had, but he has, since the initial request and since the order of determination, been informed of where he can secure the information that he's looking for if it's available. Thank you.
Thank you. Mr. Petrellis, you have 3 minutes.
Yes, Matthew was talking about information in the IRS 990 for the host committee, and that some of this information explains what it does, a benefit to the city, and that triggered in me a response about, it's spending $250,000 to benefit the city, including this party, and the head of that committee is also the head of the Office of Protocol, and like one of the biggest events they do in the year is that party, and there's no documents beyond the IRS 990 in the invitation list. It's very hard to believe. I have to say that what I like about this process I have gone through here with the Sunshine Ordinance Task Force is that you have helped clarify the documents that I do need to ask for, and I'm getting a much better understanding of the Office of Protocol and how it fits into the mayor's larger issues. And this process has taken a lot of my time, and it has all been worth the time. Thank you.
Thank you.
Thank you.
At this time, is there a motion?
I'm not exactly sure what motion to make. Is it a motion to find compliance or not find compliance?
Typically, if we feel that there has been compliance, there's no motion made. A motion would be made if we feel that there's some additional work that needs to be done to comply with the order, or whether we want to send it back to the full task force.
Okay. Well, I'm not going to make a motion then in that case, and just to explain very, very briefly, I understand the complainant's frustration at the representations that these certain documents do not exist. I understand the sort of skepticism about the intermingling of the Office of Protocol and the San Francisco Host Committee, and that this Ms. Schultz is the head of both. I'm not sure that in her role, wearing her hat in one, and specifically when she wears her hat in the Office of Protocol, I don't think that she needs to divulge information that she controls in her other role with this private entity, the San Francisco Host Committee. So, that's kind of my thinking there. I think that there has been probably, I hope that you've, as you've said, learned other avenues of finding out information, but I'm not going to make a motion at this time.
Okay, I'm not either. I, too, have learned a lot from this process, and I always do from cases that are brought before us. And I hope that one thing, I appreciate, Mr. Godot, that you came today. It would have been great if you had been able to come to the original meeting. That's part of the frustration that we face, is when the person who knows most about what's going on doesn't come. So I appreciate that you're here, and I also heard you say that you understand now more fully how to respond when someone comes forth requesting information. It is a part of the Sunshine Ordinance that people work for city departments and agencies, commissions, are to work with the requester to make sure that they understand what's being requested. The burden is not on the member of the public because it's confusing what goes on here, and so the member of the public doesn't know what to call certain things or who might have the information. So it's written in the ordinance that it is incumbent upon the city employee, city official to help the requester. And to go so far as to, give contact information, go see this person after you've clarified what's required. And also to know that sometimes the information doesn't exist in the form of a public record. Sometimes it exists as, this is how we do things around here. It's not written down anywhere, but because I think fundamental to so many matters that are brought to us is just the member of the public wanting to know how things work. And they didn't work. It didn't work well for them in some cases. And now Mr. Petrellis is actually coming here more as a public servant, or activist, saying, "Okay, I want to find out how this works." But there are other people who need something for, a court case. Now I'm giving a lecture. I'm sorry. I am a college professor, but I'll stop now. So I just, I hope you'll take this with you today. And know that it's a matter of trying to figure out what the member of the public wants, clarifying that, and then being as helpful as possible. So, and thank you so much for coming today, and thank you, Mr. Petrellis, for bringing this to us. Okay, all right. Is there any public comment on this? Before we...
Good afternoon, task force members. Thomas Piccirillo. I welcome Mr. Hebner to the Compliance and Amendments Committee. This item on your agenda, I think, segues perfectly into your agenda item 6, the grand jury report regarding lack of transparency and failure to provide documents requesting activities in the city. I would have liked one of you to have asked Mr. Godot whether or not at one point the documents did exist, and perhaps the mayor's new public records destruction policy eliminated those emails, eliminated items budgeted. What he told you was that documents are not available today. But Mr. Petrellis requested those documents 6 months ago, and the fact that it took 6 months for Mr. Petrellis to have his hearing, you put him at a disadvantage, because the facts are not fresh in his mind 6 months after the events. So you need to have your hearings in your 45-day rule, because you are putting complainants at a great disadvantage when you hear matters 5 months after the fact. It's very simple that the documents at one time did exist. They don't exist today. But that doesn't justify the mayor not retaining those documents. So I would have preferred to have a motion to either continue the matter or bring it to the full task force, so there would be more probing questions regarding what documents existed in December of last year when Mr. Petrellis asked for them. Thank you.
Thank you. Is there additional public comment on this matter?
David Pilpel. Assuming this is not coming back before the task force, I had just a couple of brief comments on the matter. I agree that we've all learned a lot about the Office of Protocol and the relationship with the two committees. I think what would be helpful for the public generally is to request or ask Mr. Goudeau to put together a brief couple of paragraphs that summarizes what the office does, what the relationship is with these committees, who to contact, the contact information that was provided in the letter dated yesterday, and put that up on the mayor's website under the mayor's office's Office of Protocol. So there's some general explanation for how this works, and including a reference to Prop F of 1998, that there really is, I think as Member Hepner pointed out, a way that things work, and that should be explained, and that if people want more information, they can certainly request it of Mr. Goudeau, or they can go to the two committees, and here's the contact information. I mean, it's not like a long thing. It's like a few paragraphs, a page, and I think that makes sense for this function. And then I think we've all learned something from it. So if you could make that request to the mayor's office, I think that would help bring some closure to this. Thanks.
Thank you. Is there any additional public comment on this matter? Okay, seeing none. Let's take item number 5, general public comment.
There being no motion, item number 3 is concluded. Item number 5, public comment. Members of the public may address the Compliance and Amendments Committee on matters that are within the committee's jurisdiction but not on today's agenda.
General public comment. Hello, Michael Petrellis again. I am very concerned that the Sunshine Ordinance Task Force doesn't have enough sunshine in that the monthly meetings, the full task force meetings, are not aired on Channel 26. I've heard that the estimate for airing once-a-month meetings could run from $20,000 to $40,000, okay, in terms of the technicians needed, equipment, etc. If the figures between $20,000 and $40,000 are accurate, and I can't say that they are, it needs to be brought to the full board of supervisors for extra funding to put these meetings on Channel 26, also make them available video on demand at sfgovtv.org. I think that part of my frustration with the task force is that the work that you do over the years is not being shown to the public. I don't believe you have more than a relative handful of people who listen to the audio. I think that many folks in San Francisco who watch government, our government watchdogs, at their convenience, at their computers, can at 2 in the morning or 2 in the afternoon go to SFGov TV and watch the Planning Commission. They can fast forward. They can stop. They can the video. They can also look at closed captioning, which is a basic transcript of all the proceedings. So I hope that with a more functional task force, shall we say, that you all take up the matter of putting these meetings on television and asking SFGov TV folks, who I think are in the basement, I'm not sure where they're located here in the building, what the estimate would be to start airing just the full meetings first Tuesday or so of the month. Thank you.
Thank you. Is there additional public comment for items not on the agenda? Okay, seeing none. Mr. Young, would you call the next item on the agenda?
Item number 4, file number 14026, hearing on the status of the order of determination, Craig Gold against Chief Greg Sir, San Francisco Police Department for violating Sunshine Ordinance Section 67.21B and C for failure to comply with requests for information in a timely manner and failure to provide assistance in identifying the existence, form, and nature of any record or information.
All right. Is Mr. Gold here this afternoon? Mr. Young, did you hear from him?
I have not received any information concerning his attendance at today's meeting.
So, what we have is an email from the police department as following up to the order of determination, indicating that they have provided all the responsive information. I don't know how we would determine that without Mr. Gold here, without hearing. So, Mr. Hebner, Member Hebner?
If I may, I mean, I think that we have sort of limited options given Mr. Gold's non-attendance, but we can ask questions about what type of follow-up was done. I note that this complaint was heard before the full task force on July 2nd, and the email response, which was supposed to be given within 5 days, was actually provided on the very next day. So in my concern is with respect to the police department's search for any additional responsive documents, what took place between having it heard before the task force on July 2nd and July 3rd, what efforts were made. I do note that on July 3rd, the email was sent at 4:12 p.m., so there is theoretically an entire morning during which public records may have been sought.
Right.
Yeah, and my understanding of it, so we haven't heard back from Mr. Gold either, so we complied with that email, as you said, was sent on July 3rd at 4:30 in the afternoon, and we have not heard back from Mr. Gold either.
Can I have your name for the record?
Yeah, sure. Sergeant Anthony Pedroza, Pedroza, appearing for the San Francisco Police Department on behalf of Chief Sir.
And Mr. Pedroza, do you have any knowledge as to what efforts were made by the police department to find additional records responsive to Mr. Gold's request?
Yeah, so I wasn't at the original hearing. My understanding is that he was provided everything. It wasn't done in a timely manner. So the email sent on July 3rd that you're referring to was asking Mr. Gold if he needed anything further regarding his original request, which had been answered, just not in a timely fashion. And we obviously haven't heard back from Mr. Gold, and obviously he's not here today for us to find out if there is anything else. So we're basically searching for nothing without a response from Mr. Gold to our email.
I do know that this email includes a request for Mr. Gold to, it seems to be an offer. If you're looking for any other questions or documents, please let us know.
Yeah.
I think that was probably made in good faith, and don't know what to make of Mr. Gold's non-response.
Yeah, we don't either. We can't go forward without a response from him.
Right, yeah. The order of determination explicitly says that we ask you to work with him to make sure that you understand what he's looking for. I think we were all, those of us who heard the case, were really struck by the importance of this information for him and because of the effect on his livelihood. And so we wanted to make every effort to have you help him satisfy his desire to know what happened.
Yeah, and we felt with the emails that we had received from him from the past case, which obviously has already been heard, that an email the day after the hearing was going to be sufficient. But like I said, we haven't heard from him via email, phone call, or in our office at all. So that's the only effort that we can make. I thought it would be here, but it's obviously not.
Right.
Yeah.
So I think one thing we can do is we could continue this matter to the call of the chair. And if...
May I make a suggestion?
Sure, please.
Long term, we have many items that are continuing to the call of the chair, and there's no way for me to close them out. May I suggest that we conclude the matter? I will send an email to the complainant stating that we have concluded the matter, and he has the option to reopen within 6 months if he so chooses. And I can administer that. So we do not have these pending complaints continue to the call of the chair with no resolution.
Right, I was actually going to ask you to put together a spreadsheet of these so I could sort of track them and figure out what to do. Well, that makes sense to me. There's one other part of this order of determination, though. It says it's further requested that the police department review and amend their policies. Oh, okay. Yeah, this was a key thing, I remember. Okay. We wanted the police department to review and amend their policies to account for the possibility that public records requests may, in certain circumstances, be submitted in the form of questions. So I think that was the original problem that we saw. He was asking questions. He wasn't asking for documents because he didn't know what to ask for.
And we'll when we get questions in the form of interrogatories or that we feel are, we'll still make our best effort going forward to try to answer those or to provide the resources.
Right.
And that's no problem at all. We broke it down kind of into two ways. That, the future in this specific case, because our understanding was he did get what he needed, but if he needed anything further, we would. So that issue, going forward, that's no issue at all.
May I ask just on that second point?
Sure.
Actually, it was the portion of the order of determination that I insisted make it in there because I was a bit frustrated that his questions appeared to be being dismissed on the basis that they weren't being submitted in a formal manner. Mm-hmm. I'm curious what, if any, conversations took place at the police department internally regarding that portion of the order of determination.
Basically, just like I said, it's a former employee who responded to that inquiry. There's not much we can do about that, but going forward, that we have made sure, especially at Police Legal, that going forward, if there are similar types of requests, that we'll make our best efforts to answer them, or at least to direct in the right direction.
Okay, so Police Legal has been whatever that I assume that's the counsel for the
police.
They've been advised of this portion of the order of determination and are apprised of the modification.
Oh yeah, we've
actually
policy. Decided to do that almost on our own.
Okay.
Yes.
Thank you. And I have no further questions for you. I am moved by the suggestion that we close this out and send an email to Mr. Gold with the option to reopen it.
I think that's a good solution. And I just wanted to say that you may have heard my little lecture to the mayor's office about that it is in the Sunshine Ordinance to help requesters, figure out how to ask for things, identify what they're looking for, and respond to ill-formed questions and requests as best you can. And to also recognize that the information isn't always in a record per se, but is an explanation of how you do things. So it's encouraging that the new direction you're going in. I think it'll, in the end, help you do things more efficiently and perhaps save you from having to come back here, you or your colleagues. So thank you very much.
Okay, sure.
So is there any public comment on this matter?
Thomas Piccirillo. Normally on matters like this where the complainant doesn't show up, you normally continue it to the call of the chair. And now, if what I hear Mr. Young saying, you're concluding this matter. I would object to the conclusion of this matter. how was the complainant noticed of this hearing, and was there any response? I'm opposing the motion to conclude this matter. There's no reason that you can't have a matter pending indefinitely. If Mr. Gold did not receive the documents or the help that he sought, he should be able to come in front of this committee and make that argument. You do have rules regarding reconsiderations of your hearing. Perhaps Mr. Gould should be advised that he can reconsider your ruling today in concluding the matter, and maybe justify why he's not here. But don't conclude the case. There's no reason to conclude the case. You can continue to the call of the chair, and then if he has a valid basis to convince you that the police department did not provide the documents or the assistance that you mandated in your order of determination, he can come back in front of you. Thank you.
Thank you.
David Pilpel again. Just wanted to advise the committee, particularly on Member Hepner's question about police procedures for handling public records requests. I do have that on the list for the EOT to deal with in several months. It's not number one on the list, but it's a few months down the road, depending on how we deal with our backlog. But it seemed to me that police department records, whether they're arrest records, incident records, whatever records related to the police, are pretty important, and getting some further clarity on what their policies, procedures, forms, checklists, how they go about this is pretty important, and we haven't had a general check-in with the police department on that in a while, so I was intending to do that at some point, so it's not lost.
Excellent, thanks.
Thank you.
So I was listening to what Mr. Piccirillo had to say. So, Mr. Young, you're offering as a way forward here, you will contact Mr. Gold and let him know that for now the matter is completed, but he is welcome to reopen it.
Yes.
Okay.
That is my suggestion.
Mentioned that we missed having him at the meeting today, and
Yes, I will draft a letter for your review.
thank you so much.
If I may?
Yes.
Sorry.
No,
Excuse me.
go ahead.
But I do want to, it just seems that the practical result is the same. It still puts the onus on Mr. Gold to contact us if he wishes to reopen it, and we would be willing to do so if he were to contact us with a concern. My thinking in listening to Mr. Piccirillo, I was a bit surprised that that he was opposed to closing this matter, given concerns about our backlog of complaints and wanting to reach some finality with things. And while I hope that this is not final, in that I hope that Mr. Gold comes back to us with further concerns, I do think that this is a sort of a way to keep it clean and move forward.
I agree. We're not saying you can't come back. We're saying we understand you weren't here. We would like to hear from you. You're welcome to resubmit.
Yes, and just to let you know, there is no requirement that the complainant attend the subcommittee meetings or the committee meetings.
Right. It's just in this case, and we really needed him here.
Yes.
Because of the nature of his complaint. That's not always the case. You're right. Mr. Young, would you call the next item on the agenda, please?
Item number 6, file number 14065, Civil Grand Jury Report, Ethics in the City, Promise, Practice, or Pretense.
All right. At this time, I'd like to invite members of the Civil Grand Jury to address us. And we're particularly, at this time, as I indicated yesterday, we're particularly interested in hearing from you regarding recommendations 20A and 20B, although please feel free to add any other thoughts. Welcome.
Oh, 20A and 20B.
20A and 20B.
Yeah.
Right.
I just before I might as well just sort of start.
Okay.
The discussion that was going on when I walked in today about the host committee and the mayor's office of protocol. Nothing's posted on the mayor's website about this committee, and it would definitely fall within the ordinance as something they should be posting information about. As somebody that supports the work of the mayor's office and provides substantial, funds or services, et cetera, in that regard, under 67.29-6, and that's recommendation 12.
Right.
That we try to address this, and there it is.
Right, exactly. I realized that too at the time.
I don't have a lot to say about 20A, one way or another. There's sort of a concept that the grand jury felt was important, that there ought to be some lengthy discussions about what's been going on with the task force and the relationship between the task force and the Ethics Commission. And people thought it ought to be organized by the mayor's office. Since you guys are sort of in the legislative branch, I don't know what the best approach is on this, so we sort of throw this out as a placeholder for the concept of this ordinance needs some revisiting. We're 15 years on from the last vote on the ordinance, and really over 20 years since the thing has been enacted. And the world's changed a bit. There's some things that probably need to be strengthened, some things that need changes. And some sort of forum is needed to talk about this. And whether this is the appropriate way to do it or there's another way to do it. And from what you've been saying, I understand there is another way that's being considered at this point. So I look forward to hearing more about that as well. With regard to a hearing officer, I go through the ordinance. I see the thing about the 45-day determination on whether something is a public record or not, and that's a very short time frame to have a formal process. But you do whatever you have to do, and there's really no procedures that are outlined in the ordinance as far as I can see. There's just this one 45-day time frame for a particular item of determining whether something's a public record or not. And then everything else is kind of up in the air in terms of people complaining about other kinds of violations of the ordinance and things like that. And basically, in those contexts, you're sort of making a determination that you think the ordinance has been violated and you're going to refer it to somebody that's got enforcement capabilities, which just drags everything on and on and on for whoever brings a complaint. And so our thought was, get this stuff before a hearing officer as quickly as possible and see if you can kind of end up with a hearing record that's useful for your purposes and useful for the Ethics Commission purposes. And I think it's something worthy of exploring because I think you spend a lot of time in your meetings dealing with these items. And it's hard for you to do the appropriate kind of judicial fact-finding or quasi-judicial fact-finding that's needed to put a good record together. You're sort of getting in a situation where people have opinions and different people are asking different lines of questions, and it's kind of hard to drive things to a real conclusion. And in the course of 20 years, here, plus you've got some function in administering the state law's application to the city practices as well. There's a whole body of case law that's been developed that has to be kind of considered and distinguished. Because if you don't do it at the front end and things grind along, it's going to come up later. And that's basically what we're trying to say. And I realize the format of these grand jury reports is a little difficult. There's a certain categories of responses and things like that. So we tried to make the recommendations fairly general. So, you can kind of go, well, we're going to do something kind of like this, or, kind of, so you can use what we're saying to support what you're trying to do, even if it's not exactly what we're necessarily recommending. But we're really trying to encourage, some changes and some streamlining of the process.
Thank you. Do you have any questions, any comments?
Yeah, I'm just on the topic of the hearing officer. I think it's a really interesting idea. I'm at the sort of infancy of understanding the roles of everybody involved in this task force, and I'm curious how you see the hearing officer functioning between sort of the city attorney's initial assessment of the case and potential violations, Mr. Young's provision of a packet of information for us to review, and what I perceive as our somewhat necessary quasi-judicial fact-finding mission, because we need to take a vote. I will say that it's a lot of information, and I don't know the extent to which each member of the task force is capable of reviewing the hundreds of pages necessarily prior to the meeting, and so that maybe that's a reason why our sort of fact-finding element of the meetings is very prolonged. But I'm wondering where the hearing officer fits in between the roles of the attorney, the clerk, and the task force. I mean, do they essentially obviate our consideration of the matter? I mean, if that's the case, that's the case. But
I think in a way that kind of synthesized that information for you. And I apologize. I don't know exactly what your files look like. I see more. I saw a lot of your referral letters to the Ethics Commission and to other enforcement bodies, and at that point, the letters are fairly compact. There may be a lot of materials with them. But it would seem to me that the city attorney is always in kind of a complicated space where they're also representing the city department or city officials involved, and they can talk about, oh well, we compartmentalize things, but it's tricky.
Yeah.
Well, and
let's face it.
That raises the next question I was going to ask, because I mean we are aware of that tricky dynamic. And for instance, just last week, I don't know if you were or 2 weeks ago, I don't know if you were present for our fairly prolonged analysis of this legal issue, on which we essentially disagreed with the city attorney's assessment of it, after or at least wanted to develop the inquiry to make our own independent determination of a very complex legal issue. And I'm wondering if we wouldn't run into that same problem with a hearing officer. How, and having just been through a scenario in my personal work where we struggled so hard to find what even met the pale of a impartial hearing officer. How do we find who would that hearing officer be? Where would that be? Where would that person come from? It's a practical question that I think could move the conversation forward.
Right.
Because I'm interested in it, but I don't know how to find that person.
And I don't have a clear answer for that. I mean, the thinking is that there is a class of people that do this kind of work. At the state level, it's more organized than anything we're going to see at the city level. But if people are doing this kind of work, they have sort of standards that they follow in terms of putting a record together and sorting out the legal issues involved and getting things sort of positioned for a decision by the body involved.
Okay.
What I am hearing here is that the nature of the decision that you would make or the Ethics Commission would make might be somewhat different.
I'm wondering, I'm intrigued by this. Anything that would make matters move more quickly for members of the public would be very welcome. And so I'm not an attorney. I have to say that up front, and I don't really know what you say the hearing officer would put together the record. I'm wondering, is that similar to what our own deputy city attorney does when he or she drafts a memo that states the complaint and cites the parts of the ordinance that have possibly been violated, and then reviews gives us an outline of what the complainant was asking for and summarizes the response by the respondent, and then cites applicable cases, and then gives us questions to help us to guide our inquiry. So we always have that. Although in the past we didn't always have it because we didn't have an attorney for very much time. But now we have these memos that we rely heavily on. Then we have all this information. Is that what the hearing officer would do? Would be to draft a memo that's like what we receive now? Or
If I could,
Please,
Elena
yes.
Schmidt, and I've had some experience with hearing officers in a different context. So the context that I worked in was at the California PUC, and all rate cases and all cases go through an administrative law judge. But it starts out with the commissioners giving direction, saying, this is what we need in order to make a decision. Please find out what you can find out. So it's important that you can say to the hearing officer, on its face, this is what it looks like. Can you figure out what's going on? Number one. Number two, if you decide to have a hearing officer, it's a public hearing.
Right.
So it is taking the time out of so that you don't have to stand here and listen to all the details in order to get to the big picture. That the hearing officer would hear both sides, synthesize it. They also have a chance to comment on it, synthesize it, and give it to you and say, okay, this seemed to be the issues, here's the law, all that kind of stuff. So what you're getting now is, as I understand what you just said, what you're getting is memos that say, here's what I see happening. So it's one person. But the hearing officer is the impartial person who's hearing both sides and saying, here's what's coming together, here's what you need to do to know in order to be able to make a decision. And then it comes back to the committee, subcommittee, or full task force to make the decision.
So that is quite different from the way we work now, and so the record that we would receive would be a summarization of what the parties said, written summary.
That's what you receive now?
No, not real. No, we receive a summary of what the complaint was and the response from the respondent, but we then have to have the hearings and ask all of our unanswered questions. So what you're saying is the hearing officer would have a hearings like we have, and then summarize the responses from the parties for us, so that facts and evidence that each side is presenting would be summarized for us.
But I think the point Elena is also making is if it's something that's going to resolve really quickly, you don't have to use a hearing officer. It's sort of
right. This is for the complex
this is
ones.
complicated.
Right.
And we need to sort out these issues. Like, what is the current case law on personal information that can be withheld? What is the current situation with this particular fact pattern? And then you hand it off to a hearing officer, and you get a more fully developed rationale for making a decision at that point.
And then that would come to the task force, who would then determine whether there's been a violation of the ordinance.
Right. And I do want to emphasize what Rob just said, which is it would be the more complicated
Okay.
ones. It wouldn't be all of them.
So I would imagine a process. We have a standing committee called the Complaint Committee, which hasn't actually been convened for a couple of years. But I would imagine that could be the committee that takes a look at the incoming complaints and says, this one is straightforward. We've heard this type of thing before. We can handle this. This one is a mess. The record, I mean, what we're given is a mess, and these are issues that we've grappled. Okay. And then so those would go to the hearing officer, who would then, we would be presented with a document that would pinpoint all of the relevant case law and issues and weigh in on how the facts and evidence should be regarded or could be regarded. I mean, it would be us ultimately, and then brought to the full task. Okay. All right, this is really different from what I envisioned was going on. So.
Right.
And I'm also thinking about this vis-a-vis.
It's really about making the process work better. It's not really about changing authorities or anything like that.
Okay, so yeah, okay. I want to capture not changing the authorities, because that's the sticking point with a number of parties. Now, this is really helpful. Member Hepner,
Yeah.
who is an attorney.
It's one hat I wear. I'm curious more generally, in your preparation of this really amazing document, frankly. I mean, it's such an education for me at this point. Were there any other models that you've looked at? I know you mentioned, Ms. Schmidt mentioned the California PUC as one sort of functioning model that does some things differently, but anything else that we can, sort of expand our own research on? I know Connecticut has a Freedom of Information Committee that is apparently a very high functioning, slick, parallel to what we're doing here. And I'm wondering if there's anything else that you guys can think of that we can, sort of do some of that real base research or modeling after.
I can't say that. I can't point at anything in particular myself.
Okay.
I think one of the things we learned is that the rate board uses uses hearing officers.
The rent board does.
The rent board.
Rent board. Oh, okay.
Oh, the rent board does. Well, and so does the.
If you meant using hearing officers, yeah.
Yeah, and well, actually, so does the rate board. But I'm not a particular fan of that.
And why not, if I may ask?
Well, actually, I stumbled before the rate board one day just because I got a postcard in the mail, and the ALJ made certain representations about things that were going to be in her decision, and they weren't. And the rate board kind of acted in a high-handed manner, shall we say.
Okay. So that may have been a function of the composition of the board itself more than the procedural.
Yeah, Ed Lee was on the board at the time. He was city administrator. And, staff hadn't postured the thing properly, and he was more concerned about fixing things up for staff. But
I wanted to ask some questions about, so 20B, we sort of get what's happening there?
Yeah, I think I'm satisfied with that. I think that was very informative.
Yeah, I understand better what that would entail. So 20A, this would be a committee that would look at amending the sunshine ordinance possibly. So just to, you may know this background information, but this committee, I joined the task force a little over 6 years ago, and when I did, I was on this committee almost right away, and we were putting together amendments. We spent, and it had been ongoing prior to my joining the task force. You know, a lot of it was cleaning up the language. There were some more substantive proposals. And then the composition of the task force changed. And there was discussion of what do we do with these? Do we take this to the Board of Supervisors, have them put it on the ballot, and there's a lot of mistrust about that process, feeling that many members of the Board of Supervisors are not particularly sunshine ordinance friendly. There was a bad experience in the past with that. So some talk about having an initiative process and how difficult that is. So, just timing and what, do you do it in a midterm or a general election, or when do you do it? And then, as I said, the composition changed. And then we decided, this is when Rick Nee was chair of this committee, we decided to do a sort of pull out the biggest items and maybe 12 that we really thought needed to be changed. And then, so we had many more meetings, and we winnowed down all the suggestions from the big overhaul we did. And then it kind of languished, because which way do we go? We want to strengthen the ordinance. What's the best way to go about doing it? So there's a feeling among the activists, the sunshine activists, and many of whom served on this task force, that this really needs to come from the voters. So that's, I believe, is how those who have been working on this, living and breathing it, would want to see the ordinance amended. So just to put that out there. The whole other issue, though, is sunshine, and you mentioned this, the Sunshine Ordinance Task Force and the Ethics Commission. And boy, they, from our perspective, do not support us at all. And we, several years ago, had a joint meeting with them. They proposed some new regulations for how to deal with our complaints, or our referrals for enforcement. And we responded, and we had a joint meeting, and thought that we were on the same page, and it hasn't panned out that way. So that's a tough nut. And if I could see a blue ribbon committee tackling that, because I don't know if we could do that through the amendments, amending the sunshine ordinance, other than to make it clear what the responsibility of the Ethics Commission is, and they're the ones that can enforce things. We can't, and so
and their enforcement powers are basically as an administrative enforcement. Okay, so it doesn't, any criminal enforcement is going to be by the DA, and any kind of high-level civil enforcement is done by the city attorney. So it's kind of I sometimes as I read the Sunshine Ordinance, I read the ethics laws, I kind of feel like they were written to make people feel that there was something going on, but they set up a process that's so complicated, it makes it very hard to punish people. Now, fortunately, in the Sunshine area, you've got some state laws, and you've got an ability to go right into court to enforce the ordinance. And the courts are usually a lot more straightforward than this. But when you bake things through a administrative process, things can just grind on and on and on. And, you know, I mean, people like the DA will tell you, oh, if there's a process going on over here, I'm not going to get involved.
Yeah.
And it just becomes a license for people to avoid responsibility in a lot of cases, I'm afraid.
I've been thinking about what enforcement power we do have, and it seems that the only enforcement power we do have is to drag people before us and be deterred by the length of our meetings and, you know, not want to come talk to us. And maybe that will force them to comply. Or as I think you said last week, and I wrote it down because it was really good, the potential for shame is the greatest deterrent to acting inappropriately. And
televising your meetings might be good in that regard.
yeah, and that's actually, I think there's a lot of truth in that. There are a lot of reasons why we should be televising these meetings. And a lot of reasons, I suppose, why people would not want us to televise these meetings. I'd love to be on TV, but that's a sort of separate conversation. But I am, you know, intrigued by the enforcement dynamic and that sort of deferring responsibility for, you know, enforcing laws because you can say, oh, they're doing it over there, when in fact we don't really have much ability to do it.
Right, and I think if you started the discussion again with the Ethics Commission along the lines of, let's try to get a hearing record together that if we're making a referral, you can work with, because people have an option at the front end about whether they come to you or they go to the Ethics Commission. And I don't know how many people go both places from day one, probably not too many, but you know, there's reasons to try and get on the same page about putting an initial record together, you know, so things can at least move along quickly.
Yeah.
But the other difficulty in all this is, at the end of the day, you're basically, you know, calling something misconduct in office. I mean, that's sort of what you're given in your ordinance. It's sort of a label. Now, if you go over to the ethics ordinances, there's a whole thing about misconduct in office. And it's a pretty major charge. And basically the stuff in the charter for the Ethics Commission about misconduct in office controls over any ordinance or anything else. And it's like I say, it's a pretty major charge. I mean, people can be removed from their jobs for misconduct in office. And so you're going to see some kind of higher level of due process that attaches to that. Now, maybe, you know, if you think about amending the ordinance, you know, you think about some other labels to put on things. I mean, you know, that report could have gone on forever.
I'll bet.
So we had to kind of pick a few things, you know, that we weren't going to talk about, and getting into this whole misconduct in office thing. I mean, the Mercury case is really the only case they've had up there. They might have had Ed Jew up if he'd hung around much longer, but he had, you know, some criminal things to deal with that were not going to wait for any kind of misconduct hearings. And, you know, you had the same main sponsor on both the Ethics Commission and the Sunshine Task Force. And, you know, depending on the stories and, you know, so forth and so on, a person who was very ambitious and who eventually took a fall himself. So I kind of look at these and I'm like, you know, these things, I mean, I worked in a legislative context for many years myself, and I know, you know, something about good legislative drafting, and the Ethics Commission thing is not well drafted. It doesn't differentiate between the commission and the staff and things like that. It just kind of throws everything into a bucket and, you know, says, these are your powers, you know, go deal with it and figure out how you're going to organize yourself. Well, it doesn't exactly say that, but that's how it works out. And symbolically, people hold it up and go, oh, San Francisco has an ethics commission, but it's just not well structured and put together, and it's very difficult once things have been adopted by the voters to change it. And it's very difficult for the city government to put together changes to something like this and take it to the voters as well. Mm-hmm. But at the same time, if you just kind of wait for the voters to come up with something, you're not necessarily going to have anything that's well drafted either. So it's a hard place to be. And you have a history now of working with this language and trying to make it work. And I think it's important to make some statements about, well, maybe it's not about the people and it's not about the personalities, but maybe it's just, the hand we're all dealt. And it's just a hard hand to work with. And, let's figure out how you write it in a more proper manner, mm-hmm. and kind of put that idea out there and see if people want to run with it. Mm-hmm. But I would agree, it's got to come from the voters, because if it's just put on by the Board of Supervisors, whether it's all of the Board of Supervisors or 4 members of the Board of Supervisors, mm-hmm. there's going to be a level of skepticism.
Sure. So, getting back to this Blue Ribbon Committee, this could be members of the public. Completely. This is like analogous to the makeup of the civil grand jury, for example. So these are people who are very knowledgeable, interested, and passionate about this, and who would be the people who would be behind something if it came right from the streets, so to speak, rather than the Blue Ribbon Committee. So that's what you have in mind. This would not be. But somebody's got to.
Somebody's got to. Knowledgeable and people who have experience in it, and former members of the task force as well.
But who would be appointing? That's the thing.
Yeah.
Because we get appointed by the Board of Supervisors, and that's been problematic in recent years.
Right, and you have designated slots as well, where you've got nominating bodies outside of the Board of Supervisors.
Absolutely.
Which sometimes is okay, and sometimes the Board of Supervisors is not as okay about.
Right. So maybe that could be the way to get, it would be organizations nominating people for this. So the League of Women, I'm the League of Women Voters person, so the League would be a logical body, and SPJ and
yeah, I mean, if it just sort of happened organically, and groups of the League of Women Voters and some other groups said, let's form our own committee, mm-hmm. and we'll have some public hearings, and we'll try and sort this out and see if we can put something on the ballot. That could probably work pretty well. We were focused primarily on this question of the relationship between the Ethics Commission and the Sunshine Task Force. But, in terms of the other items here that we, asked for your response on, I mean, I see there's a lot of things in the law now that call for disclosure that either isn't happening or nobody really checks to see if everything, the right stuff is being filed.
Right.
And so I feel in some ways, there's always a lot of noise about, let's get some more filings on this or more filings on that. But, let's look and see what's on the books and see if that's working out, and try and make that work pretty well, and see if we can get it. At the committee meeting yesterday, one of your members talked about access for the handicapped to this information. And having documents posted that can be taken by reading programs, and read by a computer, mm-hmm. and that's very intriguing.
Right.
Yeah.
No, I was those particular recommendations. I was happy to see them, and I think just off the top of my head, I think the way to go is as was suggested yesterday, to, for example, looking at behests, outside contributions, to pick kind of the obvious ones to look at. And so start studying these matters, see what's there. We had a matter several years ago about the index of records. This is in the ordinance that all the city departments are supposed to have these, and well they didn't, and it wasn't happening. And we had a case about the police department. And they finally got with the program and did that. And they found it had helped them because members of the public knew what was there, how to ask for it. But I don't know if every department has an index of records and if they're useful or not. If
Right.
things are labeled in a way that makes sense to the layperson. So that's one thing. But so I think the idea of having some research to see, okay, this is the way things look now, and then develop a plan to. It's really what the task force. It's part of our charge actually to implement. But as you can see, our time is all taken with our hearings.
The thing about the calendars and the departments, it's really a little deeper than just departments. Like basically any officials of the city that take services are supposed to have this posted on their websites. If you just start pushing a few departments, it starts filtering down, and it has a certain visibility, and it makes a difference. One thing we noticed with the Form 700 filings by officials, there was a real problem with compliance on that. And really, it's a state requirement, even though the Ethics Commission is the filing agency here, but they really can't put any penalties on other than $10 a day. So when the state started enforcing it more vigorously, all of a sudden people got a lot better about filing their Form 700s, and then when the Ethics Commission was able to add a electronic filing option to make it much easier, the compliance has really gone up a lot in the last year. Because with the electronic filing, they can tell if people have filed, and they can send follow-up notices and things like that a lot more easily than trying to track people down by phone or by mail.
So I've learned a great deal from reading the report, which I read thoroughly, and the matrix is really helpful. You've made it easy for us to respond with this template. I've been taking notes. This will be on the agenda at next week's regular task force meeting. So I think that we, Member Hepner and I, can work together to produce some notes to, if not recommendations, but some notes to distribute to the full task force in preparation for next week's meeting. And then we'll invite you back again.
If
I
you
will be there.
We won't drag you back.
Actually, next week is a special meeting. We'll have another meeting before the due date for this.
Oh, okay.
But I think,
Your special meeting, is this going to be the only thing on the agenda, or?
We'll have some hearings. Of course, that's the reason for these special meetings, plus this matter.
Okay.
And I believe we're also talking about our committee structure as well, which we need to do so we can get through all of our complaints.
Question, and just in your perception of what we do on the task force, and as I'm wrapping my head around it, aside from complaints and hearing complaints, what else do we do, in your opinion? Or in your
To me, the biggest function of the task force is to kind of see how the whole thing's working out. Whether it kind of looks like people are complying or not complying. Are there certain areas where there's particular compliance issues? And then hopefully you can drill down on some of those matters. I think the issue of privacy, for example, it's a tricky one. And I mean, to get, I can see, signatures being redacted out of documents, but I mean, the town where somebody comes from, as well as their home address, I don't know about that. I mean, you kind of look at some of these things and scratch your head. And there's, I just lost it. There's some other areas that are kind of, at the margins. There's issues, and you've just got to look at them more deeply. We talked about email in the report, and you've got this, kind of conflict or dynamic within the city code between record retention and sunshine. Mm-hmm. And, you go through the good government guide of the city attorney, and, when he's talking about public records, it's very broad and on and on. And then when it comes to record retention, it's like, well, you can, develop your policy and destroy things. And it's not always clear which are the documents that really must be retained by a department. And, for a lot of us, I think, would think that a lot of the communications that really deal with policies being made by a department ought to be retained. Mm-hmm. And if they're coming in emails and they're attachments to emails, mm-hmm. and, you're seeing more and more, not just here, I mean, Sacramento, Washington, D.C., everywhere, where legislation, regulations, things of that nature, there's a lot of back and forth between lobbyists and the elected officials or the appointed officials.
Yeah.
And, drafts are flying back and forth. And, it's kind of revealing to see, here's what the oil industry sent to the Cheney task force, in the Bush White House that turned into Bush's policies, 2 months later. It's very revealing. I don't think the public ultimately cared that much, but they probably should have.
I did.
Yeah.
But it's important for that information to be considered public so that people at least feel a little caution about what they put down on paper and things like that.
And now, when, a number of years ago, certainly when the ordinance was passed, the city government didn't have the capability for storing or searching vast quantities of information. I mean, in my early days, we would constantly hear, given the program we're using for our emails, there's no way to really search, and it's backed up on tapes of all things, and, you can't just...
Right.
You have to read through the whole tape, and we're beyond that now. So now that we can store an infinite amount of information on whatever. So I think we could change. We could change a lot about what we ask of government to keep for us. And make available.
I mean, in terms of document requests I've made and so forth, to get the information electronically in a searchable format is wonderful, mm-hmm. because you can just kind of, these are the phrases I'm concerned about, and start searching through and see all kinds of things. And I mean, this is how it's starting to play out in the private sector as well. And you look at discovery and litigation these days, the electronic discovery is a huge part of it. And you have sort of identified search terms and things like that are approved by the court. And people go off and, go through their records and start isolating things and figuring out what's privileged and what's not. Mm-hmm. And, there's a whole process that goes with that. But it's not sort of like the one smoking gun memo. It's sort of this whole picture you start getting of practice when you see 3 years worth of emails between, two people or something like that, and you get a real sense of what's going on here.
Right.
And you don't just rip something out of context. You really, have a much fuller understanding.
It occurs to me it would be, that one of the things that would be nice to do is to be more proactive than reactive with our view of the Sunshine Ordinance and how we're implementing it. And for example, what if we were to say to each city department, I don't know the extent to which we could bind them to this, but say, hey, look, provide us a list of every officer in your department or agency, and next to that, provide us with a list of which of those officers maintain calendars that are available to the public. Just as an example of something that we could do to see, which departments or agencies have the broadest availability of records. And on another level, it kind of puts these departments or agencies on notice that, hey, this is something that we care about and are looking at. And by the way, this is in our ordinance as well as something that you need to be compliant with. Another thing, we could ask each department and agency, please provide us with your data retention policy. And we can respond to those with, this is how it shapes up to the other departments and agencies that we're looking at. This is an assessment of, how it, shapes up under state law.
I'm told those are put out as by ordinance.
Okay.
But they're not as easy to find as other ordinances.
Sure. I can imagine.
But if you ask the city attorney, they might be able to give you an electronic file with all of them.
With all the data retention policies.
Right.
Yeah. I mean, it makes sense that those would be accessible.
Yeah, I think I've seen a matrix of that several years ago.
Mm-hmm. But
Because
it's certainly worth having some discussion about those policies
Right.
and how they match up or don't match up with the Sunshine Ordinance.
Right, and issuing memos to the departments and agencies, and whether they ignore them or not is their prerogative, but at least put them on notice that this is something that we're looking at and keeping track of. I don't know. I like the idea of being more proactive, though, but that necessitates clearing our backlog of complaints and somehow getting through a lot of the work that we're still reacting to. A lot of the complaints,
But we do now have 2 attorneys on the task force, and we're about to have the final 11th seat filled. And so there'll be more of us, new energy. And we're getting really creative about how to clear the backlog in a way that's, respects the process, but enables us to. I'm excited about doing some research to see, it would be interesting to choose maybe at random or maybe very strategically different departments and just scour their websites for, okay, what are they providing, what's missing, who's doing a great job, who's not. I'd like to check in on the Rec and Park.
When I did on some of the searches of the sites about the funding, was, they'll have like a donation form that cites the ordinance, so you can search for the ordinance citation and see what pops up. But sometimes it's just a form for a donation. It's not like who made the donations or anything like that. So
yeah, I think it would be instructive to go to, say, Rec and Park. We haven't had a case involving them in a while, or the library.
Yeah.
Those 2 are favorites. And then there's the street artist program that's in another one. So.
Could I ask, what is the street artist program?
The street artist program, it was apparently a ballot initiative. It's funded by the artist, and the money goes to the Arts Commission, and there's a small staff, and they're issued license to sell their art, on the street, or in the parks. So I guess down Fisherman's Wharf area, Market Street.
Oh, down by the ferry building, kind of.
Right,
Yeah.
and so they have to get a license, and then the money for the license pays for the staff, and then they're assessed according to what's needed to support the staff. There's a full-time, maybe there's like 2.5 FTEs, but a lot of the money seems to go to the city attorney to advise the staff person about how to deal with complaints to us. It would require a lengthy discussion.
We have the general picture. Okay. Thank you.
Certainly.
Thank you.
Okay.
Thank you very much.
Is there any public comment on our discussion?
Thank you. I appreciate the grand jurors being here for the third time, and I do subscribe to most of their recommendations. In terms of the Sunshine Task Force, I think, Member Hepner is correct. I mean, the only stick you have at the present time is to bring these people here till 10 o'clock at night. And that's sort of pathetic. It is. But I think you underestimate the power of television. Televising these proceedings would have a much greater deterrent effect for department heads, agencies, and supervisors, and the mayor. So I think it's incumbent upon you. You want to be proactive? I think item 1 on your agenda would be to televise these proceedings. For a long time, the Ethics Commission was not televised. Mm-hmm. And then last year, or the year before, they became televised. And I've noticed a great change in the process at the Ethics Commission because those proceedings are now televised. And I think you can have the same effect. $40,000 is not a lot of money. With a budget of $8.7 billion. So you want to be proactive, get these proceedings televised, and I can assure you that there'll be much greater compliance. I'm intrigued on the issue of the hearing officer, but that's not realistic. That's a great expense. Hearing officers aren't cheap, and you have to fight for $40,000 to get these proceedings televised. You're not going to get the funds from the supervisors or the clerk's office that have hearing officers. So I don't think that's an option. And finally, keep in mind that Chapter 67, doesn't mandate any of the procedures that you've enacted in the last 20 years in terms of all 11 members having to hear a complaint, or giving everyone 5 minutes and then 3 minutes and then public comment. There's nothing in the initiative or Chapter 67 that mandates that you continue that process, which everybody knows is not working. So you need to change the process of how you hear complaints. I am an advocacy of finality, but when there's due process provided to both the complainant and the respondent, then I am an advocate of finality and concluding matters. Thank you.
Thank you very much. Is there any additional public comment? Seeing none, Mr. Young, would you call the next item on the agenda?
Item number 7, announcements, comments, questions, and future agenda items.
I don't have anything else to. Member Hebner?
No, I mean, my mind is spinning on all the information I've taken in today, but I don't have anything else to say.
Okay, thank you. Mr. Young, could you call the final item on the agenda?
Item number 8, adjournment.
Okay, the meeting is adjourned at 6:08.